Hi, everybody. Nice to see you here. I'm Kara Horowitz. I'm the co-executive director of our Emmett Institute on Climate Change and the Environment at UCLA. Wow, thanks for the applause already. As some of you know, it was founded as the first U.S. law school center dedicated to fighting climate change through law and policy. I want to first thank our event co-sponsors before I forget. I want to thank the UCLA Institute of the Environment and Sustainability, the UCLA Sustainability Program, and the UCLA Sustainable LA Grand Challenge, all of whom are hosting this event with us tonight. I am thrilled to have here tonight with us Julia Olson, Executive Director and Chief Legal Counsel for Our Children's Trust. I really can't think of a better way to spend my Earth Day evening than with Julia and with all of you talking about ways to fight climate change. Earlier this month, some of you may have seen this, Greta Sundberg, I may not be pronouncing that right. Do you guys know who she is? She's the 16-year-old activist behind the school strike for climate progress that was founded in Europe. She wrote this on her Twitter page. I'm just going to quote it. After talking to so many of our leaders, I have now realized that they have the climate crisis under control. They understand the emergency, and they are ready to act. So I've now decided to stop striking and go back to school for good. So of course, the date that she posted this on was April 1st. This was her April Fool's Day tweet. And the reason it worked as an April Fool's Day joke is because we all understand that, in fact, governments around the world, with a few notable exceptions, seem nowhere near ready to act with the speed and scale necessary to tackle the climate challenge. Which brings us to tonight's speaker. So Julia Olson is trying to change that. She's one of the country's most visionary environmental lawyers. She founded the organization Our Children's Trust in 2010 to focus on the threat to children from climate change. She's the lead counsel in Juliana versus United States and a series of related lawsuits. That's the climate change case that's been brought by 21 kids against the US government for violating their rights and failing to protect public trust resources. Her litigation strategy, as many of you may have seen, has garnered tremendous media attention. She's been featured in Vogue magazine, on 60 Minutes, in the New York Times, I think even maybe Vogue Teen magazine, which is fabulous. And in recognition of her efforts, she's won the Rose Walters Prize for Global Environmental Activism. I'm really thrilled to have her here. She will be in conversation after her presentation with Ann Carlson, my colleague, the Shirley Shapiro Professor of Law at UCLA Law School and a co-faculty director of our Emmett Institute on Climate Change and the Environment. Please join me in welcoming Julia to the stage.
Thank you. I'm wondering, should I turn this off or this off? We probably only need one of these on, right? Okay, maybe I'll just do that. Thank you so much, Kara. That was really kind. And I want to thank Ann Carlson for initiating this idea and bringing me here tonight. And of course, everyone at the Emmett Institute on Climate Change and the Environment who have hosted me this afternoon. You've been really lovely, and I'm excited to speak with all of you tonight. I'm going to do that there. All right. These are my clients, and they're the best clients on the planet. And part of what I want to say is that there is this rising youth movement. Greta Sundberg, who Kara mentioned, is elevating these youth climate strikes that are now happening globally. And I'm working with youth who are rising up in the courts. And I was trying to think of a good quote to begin tonight on Earth Day. And I had the privilege of listening to Barry Lopez speak last week. And I was thinking, oh, I'm going to get something from Barry Lopez. But the quote that keeps coming back to me is one actually by Chief Justice John Roberts. And he has said, "There is no better gift a society can give children than the opportunity to grow up safe and free, the chance to pursue whatever dreams they may have." And if we measured all of our government policies by that standard, we might not need an Earth Day to point out all the catastrophes that we are waging on our planet. So thank you so much for coming out. And this topic can be heavy and despairing. And so I hope tonight that what I leave you with is not just a sense of urgency for our planet and our children, but also a renewed sense of purpose about how to handle this daunting crisis that we face. And just by showing up tonight, you're engaging in a really important constitutional conversation that we need to be having at schools and in coffee shops and in churches and in every branch of government right now. And so I encourage you to take this conversation forward as you leave tonight. So I'm going to start with history. And this is a little piece of my history. That's my son, Teo. And there are moments we all have that in our life that are transformative. And for me, I had been working on the issue of climate change. But when I had children, it just hit me like a rock that we were doing something to our planet that my child and all children would have to live with and fix and suffer through. And that the actions we were taking as a legal community were not up to the task of what was bearing down on us. And so I wanted to do something about that. And my wheels began spinning. And so I founded our Children's Trust in 2010 to launch this global youth campaign to hold governments accountable. And we partnered originally with a youth group out of Ventura called Kids versus Global Warming. And in 2011, on Mother's Day, we launched legal actions in all 50 states, 10 lawsuits, global cases in other domestic courts, and youth in over 100 countries led marches, all to hold governments accountable. So that began in 2011. And I want to talk about this woman for a moment because she's been an inspiration to me. And just by a show of hand, who recognizes Paula Murray? So a few of you. Her story is really untold, and I like to tell it because the civil rights movement is really a source of inspiration in the work that I'll talk about tonight. So you'll remember between 1896 and 1954, we had Plessy versus Ferguson, which said that separate but equal public facilities were constitutional. So Paula Murray in 1944 was sitting in a law school class at Howard University, and she was the only woman in her class, and she was number one in her class. And she engaged in a discussion with her law professor and the other students in the class about why not start challenging the separate part of Plessy rather than continuing to challenge the equal part of the Plessy ruling. And they all laughed at her, and she engaged in this debate. She bet her law professor, I think it was $10, that Plessy would be overturned. And that law professor went on to co-counsel Brown versus Board of Education with Thurgood Marshall and used Paula Murray's theory to undo 50 years of that segregation that was legalized by our government. So amazing, amazing woman. She went on to do many other things. And I get so excited I forget to show you that slide. So one thing to remember about this moment in our history is in 1954, only 30% of the American public supported integration. It was not a popular idea when the Supreme Court rendered that decision. And I want to come back to that point, so just keep that in your minds. So from the beginning, when I founded our Children's Trust, we really worked under three principles. And one is that we are committed to elevating the voice of youth because they have the most to lose, they're the most harmed by this crisis, and they need representation. Secondly, if we're going to work with youth, we don't want to sell them out. And so we work with science-based standards for any remedies that we seek. Because if we're not paying attention to the laws of nature, our human laws will fail us and fail our children. And lastly, we work from a human rights perspective, and we try to invoke those foundational laws, like our Constitution, to bring claims before the courts. So why should youth be plaintiffs? I get this question a lot. Why not elderly people? Why not, can any of us be plaintiffs? And I think one reason youth are also really crucial to this time is they've always been at the forefront of social movements. So this was an image of the Mother Jones March in 1903 from Philadelphia to New York to protest child labor laws and unsafe conditions, which led to our child labor laws. And then in 1955, Claudette Colvin, at 15 years old, refused to give up her seat on a bus. She was arrested, and she became one of the plaintiffs in Browder versus Gale, which legally ended racial segregation on public transportation in Alabama. And then, of course, the March on Birmingham in 1963, which really helped transform our nation. So in more modern times, the DACA youth who gained their rights, Black Lives Matter, March for Our Lives, and the Sunrise Movement, these are all young people rising up to claim justice. And here are some of the youth that we work with. These are all plaintiffs in different cases around the world, bringing the same type of case that I'll talk about tonight in the Juliana versus US case. And we support these young people everywhere. So there's my gang from, this was in January in New York City when they were doing the Vogue photo shoot, which some of you may have seen. And they also did this short video. And so, every constitutional conversation and every constitutional case begins with a story, and that story is centered around the plaintiffs. And so I'm going to weave in some video tonight so you can hear from them directly in their own words. And hopefully...
We are the Juliana plaintiffs.
We're the Juliana plaintiffs.
We are the Juliana plaintiffs.
We are the Juliana plaintiffs.
We are 21 young people from across the U.S.
New York,
Alaska,
Oregon,
Colorado,
Pennsylvania,
Louisiana,
Washington,
the Navajo Nation in Arizona.
we know that climate change is the greatest threat to our generation.
and we wanted to do something about it.
So in 2015, we filed a lawsuit against the federal government
To demand our right to a stable climate,
Capable of sustaining life
liberty.
and property.
and to end the government support of our fossil fuel energy system.
People told us that it was hopeless,
They said we could never win.
and then we started winning.
Court after court has agreed.
that we have a right to present our case at trial.
The district court,
The appeals court, even the Supreme Court, twice.
But the government is still trying to silence us, to shut us down.
to deny us our chance to testify
About the harm that climate change is doing right now.
To our homes,
our farms,
Our cities, our forests,
our oceans,
Our health.
our economic opportunity,
and our lives.
And now we need your help
we need you to join Juliana.
to stand with us.
to fight with us.
Go to joinjuliana.org.
and add your name to the youth amicus brief in support of the Juliana plaintiffs.
Show the court that we're watching.
Our whole generation.
We know what it feels like to have our individual voices feel small.
But together our voices are strong.
They did that to, thank you. That video was part of an outreach effort to have youth from around the world join an amicus curiae brief that was filed in the Ninth Circuit Court of Appeals in March. And there were over 30,000 young people who signed on so far, but it's still growing. So who are these plaintiffs and why can they go to court? And it's because they have injuries. So I'm just going to go over some of the ways in which these young people are being harmed. This is Shatescott from Colorado. And one of his primary harms is that the forests of Colorado are dying from the pine beetle kill and the drought conditions. And this is my home state as well, so it's sad to see what's happening to the forests there. And with drought, Jamie, who comes from the the Navajo reservation and is Diné, she has been displaced because the springs that used to provide water are dried up. They can no longer harvest their medicinal plants and the plants they rely upon for their cultural ceremonies. And as Californians understand all too well, the wildfire season is extending to almost 3 months from what it used to be in 1970. So it's almost 3 months longer now. And it's why we're seeing these out of control raging wildfires even in the fall and into the winter when we didn't before. And the wildfires that are happening all across the West, including in the Pacific Northwest, are harming people like Jacob, who's a young farmer in southern Oregon. This is him on his farm. He works outside every day, and his health is being impacted by the conditions, and the economic livelihood of his family is threatened by fires encroaching on their property. This is Portland, Oregon, and Isaac, who has severe asthma, and you're all probably familiar with the health impacts of the increased air pollution, not just from wildfires, but the increasing level of ozone at low levels and the increase in pollen counts. One of our experts is an immunologist and talks about just the changing conditions of her pediatric patients. This is Jaden from Louisiana, and in both 2016 and 2017, she was hit by floods. One morning, she woke up to 5 inches of water that she stepped into out of her bed at 5 in the morning. And in Jaden's words, she stepped out of bed into climate change. And this is our youngest plaintiff. He's 11 now. His name is Levi. And he lives on a barrier reef island off of the southeastern coast of Florida. He lives at 3 feet above sea level. This is a projection for 2100 by the National Oceanic and Atmospheric Administration, your federal government, saying that his island will be underwater. But long before 2100, the people of that island will be displaced because of the storm surges, the sunny day flooding that's already affecting them, and the inability to maintain infrastructure that's critical for homes and people's lives. So why do we have this problem? Well, global fossil fuel emissions and consumption has just increased from 1900 to where we are today. But you can see by this graph that most of it has happened since 1950 or 1960. And that's a really important point that I'm going to talk about next. So your federal government, I have really bad news for you. Your federal government has known since at least the 1950s that if we continued to burn fossil fuels, it would cause catastrophic climate change. And the science of climate change has been well understood for over 100 years. From the beginning of the 1900s through 1950 or 55, a scientist, G.S. Callender, was tracking CO2 levels, and he was doing it fairly accurately without good equipment. And then NOAA took over tracking, and we are now at about 407 to 409 parts per million, depending upon which measurement you look at. And I'm just going to show you, I'm not going to go too deep into the science, but there are a couple of really important images, and this is one of them. So for 800,000 years at least, and it's probably much longer than that, there was this natural fluctuation between about 180 and 280 parts per million of carbon dioxide in the atmosphere. And you can see that what we've done in terms of just the last 150 years is we've shot that number about 120 parts per million above, 125 parts per million above what it had been for hundreds of thousands of years. And this is, I think, one of the most important contributions to science. And it shows from the paleoclimate record, they go and they take these big ice core samples, and they can show that when CO2 levels go up and down, global temperature goes up and down, and then sea level goes up and down. And this is hard science, it's undisputed. And the reason the oceans rise, right, is because all that heat, over 90% of it gets stored in the oceans on the planet. And that means we start to melt the ice that touches the oceans, and even from the surface warming. So this is a really important thing that I think a lot of people don't understand, is the last time CO2 levels were as high as they are today, our oceans were 70 feet higher. Like, let that sink in for a minute. 70 feet higher. And the only reason we haven't experienced that yet is because it takes a while for ice to melt. And really the only uncertainty is how long will it take to melt the ice. And the bad news is that scientists are always wrong in their projections about this because the ice is melting far faster than they ever anticipated. So that's sort of the story of the harm and the cause in terms of the science. So I'm going to walk through our claims for just a minute and stay really high level with this. But there are 4 main claims in the Juliana case. One is it's a state-created danger claim. And it says that when the government knew, if it did something, that it would put you in harm's way and threaten your personal security, and yet they still did it and they were indifferent to that harm, that's a due process violation. The second claim is a basic, the government is infringing the fundamental rights of these youth. Their right to life, their right to personal security and family autonomy, which are part of our liberty rights that are already recognized, and their right to have their property be safe. And then a third claim is about discrimination, and this is an equal protection claim. And it says that the government is discriminating against children in its policies because it actually discounts their lives when it does economic analysis and treats them as sort of less valuable in the future than we are today as adults and our economic benefits. And at the bottom there, I'll talk about this more in a minute, but the district court in our case has recognized a new implied fundamental right. And that is the right that you all now have, according to the federal court, to a climate system capable of sustaining human life. And that is a really remarkable thing that happened in 2016. And the fourth claim that I'll talk about is the public trust claim. And it's a really simple concept that when we have these resources that we all share in common, government has to act as a trustee to protect those not just for us, but for all future generations. And this Illinois Central Railroad case is one of the seminal decisions from the Supreme Court recognizing that this principle applies to government in our country. So Judge Aiken, our district court judge, issued a remarkable decision in November of 2016, 2 days after President Trump was elected to office. And I'm going to let the plaintiffs tell you some of the key parts of her ruling.
This is no ordinary lawsuit. This lawsuit is not about proving that climate change is happening or that human activity is driving it.
This action is of a different order than the typical environmental case. It alleges the defendant's actions and inactions, whether or not they violate any specific statutory duty, have so profoundly damaged our whole planet that they threaten plaintiffs' fundamental constitutional rights to life and liberty.
At its heart, this lawsuit asks this court to determine whether defendants have violated plaintiffs' constitutional rights.
The Declaration of Independence and the Constitution did not create the rights to life, liberty, and the pursuit of happiness. The documents are instead vehicles for protecting and promoting those already existing rights.
And the founding fathers were influenced by intergenerational consideration.
They believed the inalienable rights to life, liberty, and property were rooted in a
philosophy of intergenerational equity.
The genius of the Constitution is that it allows future generations to protect the rights of all persons to enjoy liberty as we learn its meaning.
Plaintiffs do not seek to have this court direct any individual agency to issue or enforce any particular regulation.
Rather, they ask the court to declare the United States' current environmental policy infringes their fundamental rights and direct the agencies to implement an enforceable national plan to stabilize the climate system.
Even when a case implicates hotly contested political issues, the judiciary must not shrink from its role as a co-equal branch of government.
Federal courts retain broad authority to fashion practical remedies when confronted with complex and intractable constitutional violations.
Just as marriage is the foundation of the family, a stable climate system is quite literally the foundation of society, without which there would be neither civilization nor progress.
Exercising my reasoned judgment, I have no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society.
So we're fighting to hold on to that ruling right now, and I'll give you a little update about where we're headed next. But one thing to know for those who aren't lawyers or law students in the room is when the courts are looking at a newly claimed fundamental right, so whether it's the right to marry or the right to bear arms or something that hasn't been previously recognized, they do this analysis where they look at our nation's history and traditions, and then they look at whether the right is deeply rooted and implicit to our ordered liberties, okay? And so we turn to founding documents, we look at our Constitution and the Declaration of Independence. And does anyone remember that the Declaration of Independence says that our unalienable rights are those that we are endowed with by our Creator? They are not rights that men give us, that are created by human law. They're our natural rights. And so the idea that we would not have a natural right to a climate system that sustains life is absurd to me. But that's what we will argue as we go up to the Court of Appeals and to the Supreme Court. And so for people who understand about the more conservative jurisprudence on the bench and at the Supreme Court, they really care about what the framers of the Constitution believed at the time. So let's turn to the architect of the Fifth Amendment. James Madison in 1818, after he completed his term as president, he gave this historic speech. And you can read it. It says, "Animals, including man and plants, may be regarded as the most important part of the terrestrial creation. To all of them, the atmosphere is the breath of life. Deprived of it, they all equally perish." That's from the words of our framers. And this was not just a fluke. He was talking about the deforestation that was happening at the time. And he was concerned about the quality of the gases in the atmosphere. The speech goes on and on and on to talk about climate change. And the reason is, these men were farmers, and they deeply understood the connection between the soils and the water and the air, and that the nature around them was the source of their liberty, their freedom from the king, and their prosperity going forward. And that idea that our natural systems are implicit to our liberty has been carried down by virtually every president in speeches throughout history, which we've compiled as part of our evidence in the case. So this is Teddy Roosevelt saying, "If we of this generation destroy the resources from which our children would otherwise derive their livelihood, we reduce the capacity of our land to support a population, and so either degrade the standard of living or deprive the coming generations of their right to life on this continent." And he was saying that at the first decadal White House conference on children, and that was an address to Congress. So we know when it comes to climate change, this beautiful rhetoric has not translated into laws that protect us. And in fact, it's the opposite has happened. So the other really important part of the Juliana case is showing how long government has known about climate change and what it has done in response to that. So this report we found from 1965, Lyndon B. Johnson's White House, has a whole chapter on atmospheric carbon dioxide and climate change. And it was relatively accurate, actually projecting how much CO2 levels would grow that century. And the knowledge just continued to grow. So high-level government letters out of presidents' offices referred to the carbon dioxide problem as one that would cause apocalyptic change, raising the seas by 10 feet, thereby losing Washington, D.C. and New York. And by 1970, President Nixon's White House was saying that the quality of the atmosphere may well determine whether man survives or perishes. So this is the level of knowledge that our government has had for over 50 years. And that's a lot to read, so I'm going to skip that one, but this one is a better one. So you see all these presidents from Truman on, and this is US fossil fuel consumption. The red line is CO2 levels going up. But from the time our presidents began to really understand the problem of climate change, our fossil fuel consumption has grown. And this is fossil fuel production in the United States. You can see that it actually started to grow and climb during the Obama administration, and Trump is also perpetuating that. So we filed this case against the Obama administration because this is not a partisan issue. It's been Democrats and Republicans who have caused climate change. And what people don't often know is that President Obama was the self-described all of the above president. And he actually made us the #1 oil and gas producer in the world. And here's him telling you that.
I know we're an oil country, and we need American energy, and by the way, American energy production. You wouldn't always know it, but it went up every year I was president. And that whole suddenly America's like the biggest oil producer, the biggest gas. That was me, people. I just want you to. So.
That was in November of 2018 when he gave that talk. So just to erode the notion that this is just sort of President Trump taking us down this path, it's been every president. And this just shows the projections from the Department of Energy about our fossil fuel use. It's still 80% fossil fuels. And it's really because of government policy. There is a government-created, facilitated, and permitted system of energy in our country that pushes fossil fuels through subsidies and permits and the effects of the lobbying money that's coming into Congress that makes these projects the ones that our politicians choose. And I just show you this, that really the federal government controls all of these energy sectors. So until we can have the federal government stop pushing fossil fuel energy down all of our throats and really switch us to a clean energy system, the problem is going to perpetuate. So if you want to learn more about sort of that history of what the government has known, we have a podcast now. It's called No Ordinary Lawsuit. And we have a great episode that features Gus Speth, who's one of our experts in the case. And so you can learn more about that at our podcast. Just a little plug for that. So scientists have said that judicial relief may be the best, the last, and at this late stage, the only real chance to preserve a habitable planet for young people and future generations. And so I am going to talk just briefly about the remedy before I wrap up. scientists say that we have to get back from over 400 parts per million of carbon dioxide to below 350 this century. And the way to do that is, it's like a World War II type mobilization of transitioning our infrastructure, and there's so much opportunity in that. And one thing that our experts tell us, oh, sorry, I'm gonna point out this first real quick. I love this image because to me it just tells the story of how technology has really advanced tremendously, but because of this entrenched government-supported system of fossil fuel energy, we're still stuck in this old paradigm, whereas we hold these amazingly complex, fast computers in our hands, right, that used to be the size of 3 city blocks. And the other thing that we have to really focus on is creating healthier systems for sequestering carbon, so taking care of our soils and our forests. But this is the really good news, and it's not showing up right. Okay, so the way this, I don't know why you can't see this, but this is a graph of how much it costs to create energy. And it peaks way up there at the 1970s, and then up there at the 2008 recession, it goes up. And what we see is that the energy cost for transitioning off of fossil fuels is actually no more than what we have been spending on energy for decades, and is much lower than the times when we've had these crises. And this is one of our experts, Joe Stiglitz, who's a Nobel laureate economist, writes about this in his expert report. So in terms of the precedent that supports a big systemic remedy of requiring the government to prepare a plan to decarbonize our nation's energy system, there's a lot of precedent for this. We've done this in desegregating public schools and housing. Our courts have done this in prison reform cases. We've done it in the treaty rights litigation in the Pacific Northwest, where courts have overseen these big structural remedies for long periods of time. And it is simply the role of our courts not to shirk their most pressing role at this moment of crisis when all of our liberties are at stake. So the update on the case, and then I'll bring Anne up here. We were supposed to go to trial on October 29th, and the Chief Justice stopped us with a stay. The Supreme Court then lifted that stay, and we thought, okay, great, we're back on. And then the Ninth Circuit stepped in, and the Ninth Circuit Court of Appeals said, wait, we're gonna stop trial, and we actually went to review this on what's called Interlocutory Appeal, which is an early appeal before there's ever been a final decision in the case. So it's highly unusual. And so we have the case fully briefed. There's over a dozen amicus briefs supporting the case and the youth. And I'll argue in the Ninth Circuit in Portland on June 4th. And it will be live streamed if you like watching hearings. And maybe we'll get to trial this year. It will depend upon how quickly the Ninth Circuit rules, although they have expedited the proceeding, which is great news. And am I okay to show 1 2-minute clip and then I'm done?
Sure.
Okay. So again, this is the youth speaking on the courthouse steps in 2016 after we left the hearing. Uh-oh. Maybe it's not going to play. Okay, you don't get to see that one. So I will invite Anne up, and thank you so much for listening.
Those are the furniture movers. Wow. So I think it's completely obvious watching Julia's remarks over the past half hour or so that she's a visionary. It just does not take much to see what an incredible strategy this is and how amazing it is to put together a team of lawyers to file lawsuits all around the country and in some cases around the world to amass these beautiful children as plaintiffs. But one of the things that you might not see from the presentation, in part because she truncated a little bit talking about the details of the legal cases, she's a hell of a lawyer. And, and it took me a while to appreciate that. So I will confess that I think like virtually every other environmental law professor in the country, when this case was first filed, I think there was a lot of skepticism. This is big and bold and new and really uncharted territory, and we're kind of wonky, legal people who look at what does the law say, and the law doesn't say, the Constitution doesn't say you have a right to a sustainable climate. It doesn't say that necessarily that the Constitution contains a public trust obligation to control the climate. But then the first thing that happened is that they won. They won in district court, much to the shock, I think, of many, many observers. And then I started to get more serious about actually taking this case seriously and reading the court proceedings and reading the complaint that was filed and the affidavits that are filed by the kids, because they have to establish what's called standing. So Julia talked about the fact that the kids are injured. That's a necessary component of the case. They have to show they're injured in order to be able to bring the case in court. And reading the expert affidavits, and it is remarkable to read the papers in this case and to just see it's compelling, right? You've already seen how compelling it is just from listening to the presentation, but to read the crafting of the legal claims around this amazingly compelling set of facts and see these lawyers really trying to figure out how do you actually make novel legal arguments that are going to actually capture the interest and imagination of judges. And they've really, really done that. They've also amassed an extraordinary group of experts. If you go and look at she's mentioned two of them, Joe Stiglitz at Columbia. I can't remember who the scientific expert, Gus Beth is participating, James Hansen. These are the leading scientists, economists in the world on questions involving climate change, and they are on the side of the kids in this case. But then I have to say a little bit more about the kids. So one of the things that environmental law has been criticized for a long, long time, which I think is completely appropriate, is that we often take the human part out of environmental law. It can be dry and drab and boring. And for a long time, environmental groups have fought very hard against this idea that you have to establish standing in court. This is, again, to show that you've been injured in order to bring the case. Well, I think in this case, the most compelling part of the case are the standing declarations. And I had my first year students who are taking a class with me right now on climate change read the Court of Appeals opinion and the district court opinion, the second one when it came back. And I asked them, what do you think is most compelling about this case? And almost to a person, their response was the voice of the kids. It's the kids talking about injury, talking about what's going to happen to their planet. And they've made that legally real in a way that I think is unbelievably compelling and important. So that's my soapbox. Now I'll let you hear more from Julia. I'll ask some questions. But I did just want to acknowledge just the extraordinary lawyering in this case and how hard this is and how compelling they've made it, not just through the facts, but through very clever use of existing doctrine, use of history, as you've seen from some of the documents, use of very, very sophisticated experts to try to prove a lot of their points. And it's the reason they're still alive. And I don't think anybody would have predicted that, except probably Julia, several years ago.
Thank you.
So since I am a law professor and I do see a lot of my students here, I want to ask you about the lawyering, because one of the other things that doesn't necessarily come out in all this is just how hard this is. I mean, I can't imagine what your life has been since you filed these cases. And I wonder if you could just say a little bit about what you've been up against, what the hardest things about lawyering this case has been, and what your team looks like. I assume you're not doing this all by yourself. So I'd love to hear a little bit more about just the practice that has been involved in bringing this case.
Yeah, so because in the beginning we didn't have a lot of believers, we didn't have a lot of money. And so my whole strategy was I need to get people to work for free. And so I called every lawyer I knew and got referred to different lawyers. And I didn't just want environmental lawyers. I wanted trial lawyers. I wanted constitutional lawyers, people who could think outside the box. And so we have an amazing team of pro bono attorneys who work with us. And one of my co-counsel on the Juliana case is a trial lawyer. And he's donated all of his time for really 9 years. And works around the clock with me on this case. So I'm very grateful for that. And the same is true of our experts. So my strategy has been I pick up the phone or I email, cold call these top experts like Joe Stiglitz. I got a call with him and I said, so Professor Stiglitz, I have this case and here's this Nobel laureate, amazing economist. And I just walked him through it and said, will you be an expert and will you work for free? And he said yes. And he said yes because these young people, you know, it's working for children, which is an amazing, humbling thing to do. And it's trying something that hasn't been done before that just might move us off of fossil fuels. And so these experts are extremely devoted. So one thing I would say to law students is ask. Like, don't be afraid to pick up a phone and call people. But related to the hardship of doing the case, it's brutal. You know, the opposing counsel at the Department of Justice are really, under this attorney general, these attorney generals, really difficult to work with. It's the most challenging opposing counsel relationship I've ever had. We can't do any of the nuts and bolts of litigation because everything has to get approval from the higher-ups. And because the Department of Justice would not engage with us in discovery, they wouldn't notice their depositions. They wouldn't do any discovery because they kept trying to do these petitions for writ of mandamus and to stop the case. That was their game plan. We became in a crunch time. We had to do 50 depositions in 60 days. In the fall as we were preparing for trial. And they deposed all of our plaintiffs, all of our experts. We had to depose theirs. So there was a team of about 7 of us flying all over the country, back-to-back depositions. It was exhausting. So it's just been a tremendous amount of work.
Could you say a little bit more about whether the Department of Justice has changed with the change in presidential administrations?
Absolutely. Just the attitude has changed. They're not as civil to work with, and they don't follow the rules, not surprisingly. But what hasn't changed is their position on the facts. So it was the Obama administration that answered the complaint in January of 2017. And they admitted nearly all of the facts of climate change. And since then, the Trump administration has not tried to reverse any of that. And in fact, they don't have a single physical scientist as an expert in this case. So they're not disputing any of our climate scientists. I mean, imagine. So the whole, climate change is a hoax perpetuated by the Chinese, that's not coming up at all in the case.
So just for, if you don't follow this very closely, one of the very interesting things the Obama administration did right before it left office was when they answered the complaint to answer it in ways that made it virtually impossible to deny the unbelievable compelling facts about the way in which climate change is occurring and the damages that are occurring and so forth. And so if you read the government's answer, you cannot believe that this is a document that the Trump administration is actually still standing behind, because it acknowledges the existence of climate change and all the harms that are going to occur. And I think you may have some, I don't know whether you have any insight into this, but do you know strategically whether that was something the Obama administration did to set up, to make sure that a future administration would be in a very tough spot if they tried to deny the facts on the ground?
My guess is that there was some intention behind that. They really did a fabulous job with the answer and even corrected some of the numbers where we had estimated the amount of emissions in a particular category, and they increased the number because it was too low. So they did a really good job.
Really interesting. So the oil companies at one point had intervened in the litigation, and they're no longer participating. Can you say a little bit more about why? How are they viewing all this? What are they doing in it? Why'd they get out of intervening and so forth?
That's a good story.
That's what I was hoping.
So it was the 3 big trade associations, the National Association of Manufacturers, the American Petroleum Institute, and then American Fuel and Petrochemical manufacturers. And so they represent, all of the oil and gas industry. And so they were represented by a big firm, Sidley Austin, and they were actually easier to work with the attorneys than the Department of Justice, if that tells you anything. So after they lost the motion to dismiss the case and we were moving forward with discovery and we were going to trial, they really didn't want to have to answer discovery. And so we were conferring about discovery requests, and their attorneys told us that there was disagreement within the trade associations. The members were not on the same page about how to respond to questions about climate change. And so, for example, Microsoft is a member of these associations, and so is the fossil fuel companies. And so there was just a disagreement. But at the end of the day, what I think they were most concerned about was not just having to answer the discovery in our case, but by arguing that the government was not responsible for climate change or violating constitutional rights. They would have lost a defense they're now making in the damages cases where they're saying it's government, it's not us.
So that's in the nuisance cases if you're following those. So that's interesting.
And I think someone finally got wise to that, and so then they asked to leave the case as defendants when they had asked to come in the first place. We didn't sue them. They asked to come in, and then a year and a half later they said, can we leave? Can we leave? And really, just to be clear about those two different types of cases, they can still be held responsible for public nuisance, even though the government has orchestrated the system that they operate within, because they had the knowledge as well. So there's different kinds of liability, and I think they both apply.
Great. So tell us what it would look like if you won. What would the relief look like? What would the government be asked to do?
So the goal, and I think we will get this from our district court judge, is for her to order that the government prepare a plan that would require essentially our energy system to transition almost completely away from fossil fuels by 2050. And most of that transition happens in the first 10 years. It's a very steep decline, which means electrifying our energy system. And so the government would prepare a plan, submit it to the court. The court can then approve it, or if it's not up to the task, can send it back, can bring in a special master. Courts can do all sorts of things to oversee that kind of planning and implementation. And there would be very strict deadlines and targets, and then they would be tasked with implementing that plan.
So can we shift to the Court of Appeal? And so is the argument going to be mostly about whether the trial should be allowed to go forward, or is it going to be about the underlying constitutional claims? What is the Ninth Circuit deciding? And I know you don't want to talk too much about your strategy, but can you say a little bit about the direction you'd like the court to go in?
So our first argument is that they should say, oops, we made a mistake, it's too early to review your case on appeal, and send it back to the trial judge. And they can do this. So there are several cases in the Ninth Circuit where they've taken up an interlocutory appeal, and once they read the briefs, they say, this is too early.
So let me just interrupt just for a moment just to explain. Procedurally, usually what happens is you go to trial, and then when you're done with your trial, you appeal it. And what the Trump administration has been fighting like mad to prevent is it from going from any trial taking place. They're trying to short circuit the trial because they don't want 21 kids presenting evidence about what they knew and how they failed to act at trial with witnesses and all the rest of it. And so they have been going up and down the Ninth Circuit to the Supreme Court, back to the Ninth Circuit, trying to get a court to agree with them that we're going to decide these kind of very novel legal questions before we ever go to trial.
Yeah.
And so that right now, the trial is on hold. The Ninth Circuit has got to decide this question. Do we let the trial go forward first, or do we actually decide whether there's a constitutional right and so forth?
Right. And the reason why they shouldn't be deciding these questions right now is almost every question, with the exception of one or two, that they're being asked to decide are fact-dependent. And the facts have not been decided by the trial judge. So appellate courts in our system of law don't get to find facts, typically. That's dedicated to the trial courts. And then the appellate courts are bound by the facts that are found by the trial judge. So for example, at this hearing, I can't bring my experts to the hearing so that the judges can hear the experts testify about issues of injury and causation and redressability. And so it's really inappropriate for them to review these issues. They could, however, decide that when Judge Aiken said that we all have a fundamental right to a climate system that sustains our lives and our liberties, that that is accurate under constitutional law, that we do hold that right. They could make that legal decision, and they could make the legal decision on the public trust doctrine as well. But whether that right has been violated, they can't yet decide.
Great. What do you worry most about in this case?
I worry perpetually about the clock ticking. The urgency is unbelievably depressing, and so that is a constant worry and fear that we can't push it fast enough. But my biggest worry in the longer term is, how do I speak to Chief Justice John Roberts in a way that speaks to his jurisprudence on the Constitution and touches his heart? I think that I spend a lot of time. I used to think about Justice Kennedy, and now I think about all the justices, and we do a lot of research to really, figure out who are we speaking to, because it's important to know that. And obviously he's someone I'm looking at down the road.
Any of the sort of more liberal-leaning justices who you think might be sort of thought leaders on these questions within the court?
I do. So I've become a Supreme Court geek. I listen to oral arguments all the time on oea.org. If you have any interest in listening to your Supreme Court do arguments, I think it's really exciting to listen to them. And so I'm starting to recognize, all their personalities and the way they think about issues through their questioning. And I think Justice Kagan and Justice Sotomayor are going to be really interesting on the issue. Yeah.
I told you she's a good lawyer. Do you worry about setting bad precedent for other cases? Or do you
No. I don't worry about it. I think deeply about how not to set bad precedent. And I was taught in law school that bad facts make bad law. And I have the best facts of my life in any case I've ever litigated. And bad facts meaning terrible facts, right? I mean, they're terrible facts, but for winning a case, they're incredible facts. So going into it, we're strong, and we have an incredible team. I work with really talented lawyers. They're mostly young lawyers on my staff. There are about 8 of us. And we just research. We work harder than the other side so that we are not setting bad precedent.
I will just say one worry that I've heard some people express is about this question of standing. Again, can you get into court to actually challenge the government about bad decisions that's made on the environment? And I can't imagine you're going to set bad precedent, because the affidavits, again, for the kids about the injuries they've sustained, and then the connection. So you have to show 3 things. You have to show you've been injured, you have to show that the defendant is a cause of the injury, and you have to show that if you ordered the government to do something, it would relieve your injury, basically. And this is where all these experts come in, because at the standing stage, they can talk about causation. Are the injuries that these kids are complaining about, exposure to drought, exposure to more intense air pollution, et cetera, is that caused by the defendant? And they have unbelievable, the best experts in the world saying, yes, there is a direct link between what the government is doing here and what these kids are experiencing.
And so it's uncontested.
And it's uncontested, right? They're not contesting it. And so it's, standing has been a hard question in climate change cases, and I'm hopeful that this is actually going to make good law for standing. And I think that will be an important question in the Ninth Circuit when Julia argues in 6 weeks. So I don't have a clock up here, but I think that I should open up the, is it about 7:15? Anybody got a? Yes. Okay. Okay, I was supposed to open it up for questions at 7:15. So audience, now's your turn to ask questions. There are my wonderful students. I'm so happy how many of my students are here, who have microphones. So if you want to ask a question, please flag down a person on either side of you. And that way everybody can hear you in the room. Thanks.
Hi. Hi, that works. My name is Jared Thomas, and I have a background in local government in particular, and I appreciate that you mentioned ecosystems and levels of responsibility early on about how you're focusing on federal government, and even though the companies that came in originally backed out, they're still very much associated with the case later on. But I want to find out, what is your experience interacting with local governments who have the responsibility to manage these kind of climate issues, such as like providing water or waste management or things like that?
So at our Children's Trust, we actually, for years, have had local level campaigns and have helped youth go to city councils and testify and get climate recovery ordinances adopted that require cities to do climate action planning, both on the mitigation side and also on the adaptation side. So we really try to inspire young people to get activated and engaged in government at all levels of their governments. And we also partner with communities who participate as amicus curiae in our state and federal cases so that they can bring those kinds of concerns. But in terms of assisting cities with that really important planning, we don't do that kind of work, but I think it's really critical, and it's information that then can be passed up to the states and the federal government about what those local needs are, because they're very pressing right now.
With your compelling 21 plaintiffs from all over the nation, I was just very curious how it ended up now chiefly in the Ninth Circuit.
So I live in Eugene, Oregon, and we had a group of young people who wanted to join this case and be plaintiffs. And because the majority of the plaintiffs are from Oregon, we decided the venue would be appropriate in that particular district court. And so we filed in the District of Oregon, and that puts us in the Ninth Circuit. So that's how.
Because they mentioned earlier you filed like around a whole bunch of people filed around the country too, right? Lots of district courts, or no?
No, there's just one federal case. We work in other states, but the youth are from all across the country, and they're a really amazing, diverse group of youth that we became connected to through different partners. Some of our youth put the word out to other young climate activists, and I wanted no more than 10 plaintiffs, because as for attorneys in the room, you know, managing communications and with your clients, it can be a lot, and we just kept getting more and more, and finally we got to 21, and I'm like, okay, that's all. So,
thank you.
Yeah.
But there are some other state cases filed in state courts,
yes,
not in other district courts, federal courts.
Hi, Michael Zellniker in the
Oops, sorry.
Go ahead.
Oh.
We'll switch sides.
Michael Zellniker, Climate Reality Project. Is the tens of millions of dollars that the government has incentivized the fossil fuel extraction industry with, the tax giveaways that they provide, is that part of the predicate of your suit?
Absolutely. So we, in our brief that we filed in the Ninth Circuit in February, we outline 9 categories of federal government actions or components that make up our fossil fuel energy system. and the subsidies are part of it. The giveaways of our federal public lands for extraction is part of it. And then all the other components, the permits for pipelines and other fossil fuel infrastructure, and exports, imports, just the whole shebang.
Hi, I'm Suzanne Reber with Scripps Washington Bureau. I'm really interested in the plaintiffs themselves, the youth. Can you talk a little bit about, you've got some very young people in that crew. How do they contribute to the overall team, and how are you managing their personal investment in it and their their psychological well-being as this case is going on?
Yeah, thanks for asking that question. So none of the plaintiffs have to do any media work. And ironically, Levi, who's the youngest, does probably the most, or he's one of the ones who does a lot because he really enjoys it. So we present the opportunity for them to do that kind of public engagement, and they decide if they want to. And as the case has progressed, more and more of them have wanted to sort of step up and become leaders in that way and do the media work. The mental health question is a really vital one. So we have experts on our expert panel, including a psychiatrist and a psychologist, who talk about the mental health impacts of climate change on young people in particular. And it's well documented that mental health is being affected just as physical health is. And I see that in these plaintiffs. In fact, several of them put this in their declarations to the court and will testify about it at trial. So we have plaintiff coordinators on our staff that really support the youth in more ways than you can imagine. We bring them together a lot because they have told us that when they're together, they feel like they're a family and they are each other's support network. And just being around communities of young people who understand climate change and care about it the same way they do. But this is an issue for young people. They are struggling deeply with the mental health implications. And it's hard. It's very, very hard. But we do everything that we can to get them support. Yeah.
Hi, I'm David with UCLA. I think the court systems sometimes feel like a bit of a vacuum, but none of this is happening in a vacuum. It's obviously, something that we're dealing with on a daily basis, and both the impacts of climate change and the response to it have become more extreme. So I'm wondering, to what degree do you think sort of public opinion and attention to climate change and its outcomes is going to impact the case, or has impacted the case?
Yeah, it goes back to that 30% of public support at the time of Brown versus Board of Education. Today, it's close to, I think, 70% of Americans want to see action on climate change. And when we started these cases in 2011, we were still at a point in time where the media was reporting about climate denialism, right, and climate skepticism, and sort of weighing these things equally. And I think it's really shifted. I think the reporting on climate change has changed immensely. They're getting the science right more and more, and they're reporting on the work that we're doing, the work that others are doing, and reporting it more fairly. And I think it's really shifted public opinion. So I think it's critical when you're working on a constitutional case, like the right to marry in Obergefell, for example. You need people in the streets, you need people in every branch of government, you need a movement, and you need to change people's hearts and minds. And so this is campaign-based litigation, and while all of those parts are really important, I'm in it to win it in the courts, and I believe we can do that. But all of the rest of it helps lift us up. So thank you for being part of that effort as well.
This is Carlos Solano with ADAC. It's a sustainability company responding to CDP and other frameworks. if I may give some context to my question, I went to school in Houston, Texas, and it's their own bubble. So I have a lot of interesting conversations, even with professors, about these issues. Granted, I'm no longer there. And what I'm wondering is, my background is more technical, so I don't know about all the legal ramifications, but I'm wondering on a broader context, if you're thinking about a blueprint of maybe a different system from somewhere around the world. I'm thinking in Colombia, a lot of these companies are going to Colombia and we just let them go and do whatever they want in our land. So I'm wondering if somebody has reached out from a different country, or if anybody has tried to ask, how do I do this? I know systems are different and the contexts are probably different, but I'm wondering.
Are you talking about different legal systems?
Yeah, if somebody from another country has reached out to try to poke at the same problem in a different country.
We support youth in countries around the world in bringing similar types of cases. So we look to what is the foundational human rights law that is most applicable in that country that we can use to bring a similar type of case. But interestingly, do you know about the case in Colombia?
I saw the name on the picture.
Yeah. So I think it was 28 young people in Colombia brought a case modeled after the Juliana case, and they were going after the deforestation in Colombia to try to stop that. Because obviously many countries, the role they can play is more in the sequestration side than the emission reduction side, although that's needed there as well too. But they won that case, and they lost in the lower court, took it up to the Supreme Court, and they have a great ruling. And whether the implementation will happen and the enforcement will happen, we'll see, but it is happening around the world.
Hello. I'm a retired attorney, and when I went to law school, environmental law did not exist. And that's what I wanted to major in, but it didn't exist. Not only did it not exist, but there were no jobs, because people said to me, the trees don't pay, which I think is part of the bad part of the climate change movement, is that it didn't focus on humans first. So mostly, I just want to thank you so much for what you're doing for all of us.
You're welcome. Thank you.
Hi. Two questions, sorry. The first one I think you sort of answered, which when you said all sectors have a role to play. I was wondering if you might add a few comments on the legislative role in the U.S. And then the other one is, I believe the Supreme Court talked about justiciability or justice. If you could say a little bit more about that, I'd appreciate it.
So, Congress. I think in the next couple of years, we're not going to see meaningful legislation on climate change or transforming our energy system. But what I really think is important is the work that groups like Citizens Climate Lobby are doing and groups supporting the Green New Deal are doing, which is getting these issues percolating, building the relationships with members of Congress, drafting proposed legislation, because there will be a moment when the courts step in and issue a mandate. And like with the Voting Rights Act or the Civil Rights Act, Congress can be there ready to enact a comprehensive solution that's cleaner than what can happen right now with the executive branch under existing law. So just to be clear, our case can be fully implemented under existing statutory law that the executive branch already has. They have immense power that Congress has already given them. We don't need any new laws to get this remedy implemented. But you could have a more graceful remedy if Congress would step up and do some things like put a price on carbon, for example. And so I think all of that work is really, really critical. And then your next question was it about what the Supreme Court wrote in the very short ruling? So the Supreme Court has indicated in just a paragraph in sending our case back to the district court and not taking it up yet, that there may be a difference of opinion among the justices as to whether our case is justiciable. And justiciability implicates standing, which Anne was talking about and I've talked about, and it also implicates issues like separation of powers and the political question doctrine, and there are all these jurisdictional hurdles that we have won every step of the way so far, and I'm convinced we will win all the way up, but I'm sure there will be at least 2 justices on the Supreme Court that disagree with us.
Hi. Thank you for speaking with us. I've got a question on your strategy as far as the plaintiffs that you chose. So you started off the presentation with
Where are you? Oh, sorry. Okay, thanks.
with the 21 plaintiffs, each one of them with the separate story, all affected by climate change, right? You've got the child in the island off Florida with the sea levels rising. You've got wildfires. You've even got the gentleman from Colorado with pine beetle infestation. I'm curious as to the strategy of getting all different types of stories, each one of them, I think, slightly stronger in terms of direct impact by climate change, right? Sea levels rising, direct impact by climate change. Pine beetle infestation, one level down, at least that's what I would argue. And so I'm curious as to why get a wide group as opposed to getting, okay, here are 20 kids that are all from the coastal areas, all going to be directly affected by sea levels rising, directly connected to climate change, and then you don't have any sort of questions on everybody else.
So I believe that good lawyers are good storytellers, and our stories come from our plaintiffs. And there are many, many stories to be told about the ravages of climate change. And each of you, depending upon where you come from and the places you love, are going to be touched by a different story, right? And it's my job as an attorney to not just represent these youth who are my clients, I'm going to do that to the best of my ability, but I want to also bring their stories and make them alive for the judges who will decide their case. And so I only have to prove standing for one plaintiff, and then we can be in court. One plaintiff. So Levi, he's already been evacuated from his home's flooded, he lost his school, his island's going underwater, and we probably won't ever stop it, right? That kid has standing. And no judge is gonna tell me that Levi doesn't have standing. He also has nightmares from the fear of living with that knowledge. But Jacob's story is a farmer. They were immigrants from Canada. They bought this land. They organically farm, and they're watching wildfires and pine beetle kill destroy their forests, property that they're also trying to preserve for generations to come. And that story is going to resonate with someone else. So I'm telling all 21 stories in this case because they deserve to be told. They have the right to tell these stories. And those stories will touch each of you in different ways. Yeah.
I almost lost my train of thought. This is just so moving. It's biblical. We got floods, fires. It's crazy. Is part of your legal presentation going to be to have some proposals of how they could transition out of the need for fossil fuel into something that's more sustainable?
Yeah, so we have experts on the expert team who are the physicists and the technical experts about the energy system and the technology that's already available and how you can put all of those systems in place to get us off of fossil fuels. And we have a natural sequestration expert who talks about the sequestration capacity of the land. And one of the things we're doing at our Children's Trust is we're developing our own national climate recovery plan with our experts. It probably won't be presented to the court, but in the event that the administration responsible for developing such a plan doesn't do it or doesn't do it well, we'll have one ready to show the court or hand over to the defendants, and it will have all of the policies drafted that will accompany that plan. So we're working with the top experts in the world about how that transition happens. And the amazing thing is, it is so possible. It is so possible. And we have immense opportunity to create jobs and live in healthier communities if we just do it.
With those large changes you talked about in the slide about prison reform and desegregating the schools, had they given some examples of how it could be done, or did they just leave it up to the government to figure out how to accomplish these goals?
So, two quick stories. One is California prisons. And I love this because it's a great analogy. So a 3-judge panel in California said to California, you need to deal with the overcrowding and the constitutional violations of prisoners' rights. And you need to take your prisons from 200% capacity, which is what they were at, and bring it down to 137.5% capacity. Okay? They went to like a digit. And you need to do it within a set time frame. And they told California, if you don't do it, we will start releasing prisoners. And the Supreme Court upheld that decision. That's the power of the courts. Another example is after Brown versus Board of Education, school districts were required to submit plans to courts. And these school districts in the South submitted ridiculous plans. The courts got into the business of saying, you'll have this percentage of white and black students at these schools, here's your funding requirements, here's your teacher hiring requirements. They managed these school districts because the districts weren't coming into compliance with the Constitution. Our energy system needs to come into compliance with the US Constitution, and that's what we hope to achieve.
We have time for one more question, I think, from this mic.
Hi, this is fascinating. I'm wondering if you know of any other lawsuits that are percolating, that are out there, that are waiting for the decision of the Supreme Court. If there's any, and then I have a subpart to that, if there's anything that some California lawyers could participate in and help along the way.
So thank you for your question. What we're really asking people to do is, when it comes to this particular case in the federal courts, is let this case be decided before other similar cases like it are brought, because we've carefully crafted this for 10 years, and we have good judges who are really shepherding it through. There was a case that was brought in a Pennsylvania federal court that sort of copied aspects of our complaint, and they just got a terrible decision that we're now contending with. And so we don't need more federal cases, but we do need volunteer lawyers. So we have a website, ourchildrenstrust.org or youthvgov.org. And if you want to volunteer in any capacity, there's a form you can fill out, and we'll get you connected with the right people on our team. And we really are powered by, half of our budget is volunteer time. So yeah, thank you.
Happy Earth Day, everyone. Thank you so much for your participation.
Thank you.